This week's module is Module 9, the Courts. American courts are deeply involved in the life of the country and its people. Some courts, like the Supreme Court, make fundamental policy decisions vital to the preservation of freedom, order, and equality. Yet most courts, including the Supreme Court, are largely beyond democratic control. Courts shape policies that form the very heart of American democracy. They can undo the work of representative institutions and therefore represent a difficult problem for democratic theory. They do this through their powers of judicial review. This power allows the court to overrule decisions made by local, state, and national authorities like the President and Congress. Judges are students of the law, but they remain human beings. They have their own opinions about the value of freedom, order, and equality in society. Although judges are constrained by statutes and precedents from expressing their personal values in their decisions, some judges are more prone than others to interpret laws in light of their beliefs. Judges are said to exercise judicial restraint when they stay closely to statutes and previous cases in reaching their decisions. This is known as relying on precedent. Judges are said to exercise judicial activism when they are apt to interpret existing laws and rulings more loosely and to interject their own values into the court's decisions. Article 3 of the Constitution created one Supreme Court. Beyond that, there were big questions about the court system. How many? What power? Etc. The framers were divided on the need for additional courts for the national government, so they deferred to Congress the decision to create a federal court system. Congress created a federal court system that would coexist with courts in each state, but it would be independent of them, according to the Judiciary Act of 1789. The Congress provided that we would have district courts as our trial courts and intermediary circuit courts, later called appeals courts, to listen to complaints of unfairness in the original trial. Cases from the courts of appeal may be appealed to the Supreme Court as a court of last resort. In the early years of the Republic, the federal judiciary was not considered very powerful. It was hard to find people willing to be Supreme Court justices. When John Marshall was appointed Chief Justice in 1801, a period of real change began for the court. Shortly after Marshall's appointment, the court confronted a question of great importance. If a federal law and the Constitution conflict, which would prevail? The question arose in the case of Marbury v. Madison in 1803, which involved litigation based on the question of the Supreme Court's original jurisdiction. That is, its authority to hear a case before any other court does. The Constitution confers original jurisdiction on the Supreme Court to hear and decide all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. Cases falling under the Supreme Court's original jurisdiction are tried and decided in the court itself. Such cases begin and end there. The largest part of the Supreme Court's jurisdiction then and now extends only to cases that have been tried, decided, and re-examined as far as the law permits in other federal and state courts. These referred cases fall under the Supreme Court's appellate jurisdiction. The Supreme Court exercises judicial power under its appellate jurisdiction only because Congress gives the authority to do so. This congressional authority is another example of the checks and balances principle embodied in the Constitution. Thus, the power of the federal courts depends on a grant of jurisdiction from the legislative branch. In Marbury v. Madison, the Supreme Court decided that if a congressional or a presidential act conflicts with the Constitution, the Supreme Court claimed the power to declare the act void. This is judicial review. It meant that the judiciary would be a check on the other branches, which is consistent with the principles of the Constitution. The Supreme Court sits on top of a system of federal courts that were established and granted authority by Congress. Federal courts coexist with state courts. The main federal courts are federal district courts where litigation begins. Each state has at least one federal district court. The federal courts of appeals sit between the federal district courts on the bottom and the U.S. Supreme Court on the top of the judicial pyramid. There are 13 courts of appeals. The nation is divided into regions, or circuits, where the courts convene. We have a dual court system, one state, one federal, and this complicates enormously the task of describing what kinds of cases federal courts may hear and how cases beginning in the state courts may end up in the Supreme Court. The Constitution lists the kinds of cases over which federal courts have jurisdiction in Article 3 and the 11th Amendment. By implication, all other matters are left to state courts. There is some overlap, however, and federal courts do get involved in issues that were exclusively state matters if they work their way up to the Supreme Court. Other matters are exclusively under the jurisdiction of federal courts. For example, when a federal criminal law is broken, but not a state law, the case is heard in a federal district court. Today there are 95 federal district courts with more than 500 district court judges. They decide on a wide variety of cases. There are 12 plus D.C. Court of Appeals with 159 full-time judges who handle 13,000 to 14,000 cases a year. Appellate court proceedings are public, but they usually lack courtroom drama. Initially, there were only 6 judges on the Supreme Court. It was expanded during the Depression by FDR, who tried to expand the number of judges so that he could pack the court with justices who would not overturn his New Deal economic programs as unconstitutional. The court is in session for 36 weeks out of each year, from early October until the end of June. The 9 justices read briefs in their individual offices, hear oral arguments in the large, stately courtroom, and discuss their decisions with one another in a conference room where no outsiders are allowed. The court operates in secrecy and shuns publicity in order to diminish outside pressures. Enjoying lifetime tenure, the justices hope to remain immune from direct constituency pressures which might influence their judgments. The court is bound by the Constitution. It sees itself as the defender of the document, and this keeps its power within bounds. As a consequence, justices will sometimes render opinions which seem to contradict their ideological bias. Bringing a case to the Supreme Court is very difficult. The Supreme Court rejects 95% of the requests it receives. A case can enter the Supreme Court following a decision in one of the courts of appeals. A case can also enter the Supreme Court from the highest court of a state. 2 conditions have to be met. 1, the case must reach the end of the line in the state court system. Litigants cannot jump from state to the Supreme Court whenever they feel like it. 2, the case must raise a federal question, an issue covered under the Constitution, federal laws, or treaties. But even for these cases, Supreme Court review is not easily obtained. The court controls its own docket, a court's agenda. This control lets the court select a relatively small number of cases, about 150 out of the 4,000 requests it receives each year. One of the powers of the Supreme Court is making policy. Courts make policy when they interpret the Constitution in a new way or extend the scope of existing laws so that they cover new areas, or when they design solutions to existing political, social, or economic problems. The court has declared over 120 federal laws unconstitutional. Congress can bypass these decisions by passing slightly revised versions of the law that adhere strictly and narrowly to the court's decision about what aspect of the law is unconstitutional. The court can and does revise earlier decisions or create new interpretations of the Constitution. Generally, the Supreme Court tries to adhere to previous decisions known as precedents. They try to do this because if they didn't, laws would be changing constantly, making legal matters chaotic. They also try to adhere to precedents because of concerns about fairness. If the principle of equal justice means anything, it means that similar cases should be decided in a similar manner. When the court decides on a matter and includes prescription for solving the problem, this is referred to as judicial remedy. A remedy is an order setting forth what must be done to correct the problem. Usually this is straightforward. Example, the person who loses a case has to pay the winner a certain amount of money, but remedies can also affect hundreds of people and cost millions of dollars. Those who approve of judicial activism argue that the courts must correct injustices when the other branches of government fail to do so, because the court is the last resort. Others argue that judges are not experts and therefore should not make such detailed decisions that include remedies. Federal judges are not elected and therefore have no business making policy. There are 3 causes of judicial activism. 1. Increased number of cases coming to courts. 2. Vague wording in the Constitution and in legislation passed by Congress, permitting wide latitude in interpretation. 3. Desire by judges themselves to be active. Throughout most of the court's history, it has protected property interests rather than civil liberties. This continued into the 1930s, when much of the early New Deal legislation was struck down by the Supreme Court. Franklin Roosevelt's landslide electoral victory of 1936 and the scare of his court-packing bill changed the orientation of the court toward civil rights and the steady enlargement of the federal government in protecting the rights of labor and consumers. The great push toward protecting individual rights came from the Warren Court during the 1950s and 60s. The thrust of this court was to protect the rights of individuals and minorities against the power of business and government. In the area of First Amendment freedoms, the Warren Court reversed the trend of earlier courts, which tended to emphasize the need for conformity and order in favor of individual liberties. This was especially true of the rights of the accused. The Warren Court also protected individual rights in its desegregation decisions. In Brown v. Board of Education, the Supreme Court struck down all legal sanction of racial discrimination in public schools. After the Warren Court came the Burger Court, which was a product of Nixon's appointment of a new Chief Justice. In desegregation, the Burger Court tried to gradually qualify the extent to which desegregation is required in the U.S. But in the area of sexual discrimination and in First Amendment rights decisions, the Burger Court was not so different from the Warren Court. It handed down some decisions which have strongly upheld freedom of speech, assembly, and the press. The Burger Court differed the most in the rights of the accused criminal by strengthening the rights of the state, namely by reinstituting the death penalty and relaxing restrictions on search and seizure. The court, on the other hand, legalized abortion in Roe v. Wade, refused to stop the publication of the Pentagon Papers, outlawed wiretapping of domestic groups without a court order, limited the power of communities to ban pornography, banned racial discrimination in private schools, and upheld a variety of affirmative action rulings. Thus, it is hard to say that it was distinctly more conservative than the Warren Court, or that it was distinctly less active. The next court was the Rehnquist Court of Chief Justice William Rehnquist, sworn in 1986. Everyone expected this to be a very conservative court. In many areas, it was, but not initially. During the first term, the liberals won all but two of the major cases, and conservatives won only in the area of criminal law. A moderate, liberal coalition of justices, led by Justice William Brennan, decided cases on affirmative action, teaching creationism in schools, and political asylum for undocumented immigrants. During the George H.W. Bush administration, Thurgood Marshall stepped down, and Bush appointed Clarence Thomas and David Souter. President Bill Clinton would appoint Ruth Bader Ginsburg in 1993. While Thomas has been a conservative justice, Souter, thought to be conservative, has been a moderate on many decisions, with Ginsburg a more liberal justice. With the retirement of Sandra Day O'Connor, the first woman ever appointed to the Supreme Court in 1981 by Reagan, in 2005, President George W. Bush appointed John Roberts, but Rehnquist's death shortly thereafter saw Bush appoint Samuel Alito for O'Connor's seat and nominate Roberts as Chief Justice. Chief Justice Roberts was picked because of his conservative credentials, but he has been a moderate Chief Justice and not as conservative as the Bush administration thought. Under President Obama, Sonia Sotomayor and Elena Kagan have become justices. Today there are 4 justices who align as conservatives and 4 liberal justices, with Justice Anthony Kennedy often the swing vote in decisions. The most recent example occurred in June 2015 when Kennedy voted with the liberal justices to legalize same-sex marriage throughout the country in Obergefell et al. Versus Hodges. So far, the Roberts Court has been characterized as conservative justices who are a group of ideologues eager to impose their policy preferences on a divided nation, or as a group of principled jurists struggling to resist judicial activism on the left. In addition to same-sex marriage, the other 4 highest profile cases of the Roberts Court involve affirmative action in public schools, gun rights, campaign finance, and health care.